Hi, everyone. Welcome to our Facebook Live broadcast. I'm Steve Altishan, Director of Client Partnerships at Pacific Cascade Legal, and I'm here with our founding attorney, Louis Landerholm, to talk about what you can do if your DIY divorce in Oregon went wrong. Louis, how you doing today?
Yeah, I'm doing great. How are you, Steve?
I'm doing well. I'm really, really excited about this. We see these all the time. People want to do their own divorce. And, if something goes wrong, they just sort of don't know what the hell's going on, what to do. So before we get into that, let's talk a little bit about how easy it is for someone to get into this situation.
Yeah, well, it's very easy. I think the difficulty with any legal proceeding, but I think specifically divorce, um, people in general feel like, oh, maybe it's just a divorce. It's not that big of a deal. We want to save some costs. We can generally agree on, we think we're in agreement on what we want to do. How difficult can it be, right?
Right.
We're just, we can divide our stuff. It's just putting things on paper and we'll figure that stuff out later. We get along, it'll be fine, right? And so that's, I think, where everybody starts with. It's great. It's great intentions. They have the best intentions in the world that this is going to go the way that they want to go. The problem arises when, because 99.9% of the time, the people and the clients who are doing this, do this for a living. They don't live in this world all the time and just frankly don't know what they don't know. They don't know
Yeah.
how this stuff works, right? And so when you put information and you put orders into a judgment that is the final document in a divorce that then is signed by the judge, that is the letter of the law when it relates to how the you and your ex-spouse are going to operate once you're divorced. If it's not clear, if there were side agreements that nobody knows about, if they're not in the document, they don't exist as far as a judge later on is concerned. You don't get to come into court and say, yes, but Your Honor, we had agreed to do this. I know it doesn't say it in the documents, because the judge is going to say, I don't see it in the documents. I can't do anything about that. The word is the word, right?
Yeah.
In those documents. So that's what typically happens. The the difficulty is that there it's not always the terms where things fall apart. A lot of times it's the mechanics of the how things are going to get done that fall apart. People may say, for example, houses are one of the biggest places that cause the most amount of problems, because people say, oh yeah, we're going to split the equity, but we're not going to sell the house for a couple years. Okay, that's all well and good, and that can be done, and we do that all the time. The problem is they don't know how to plan for the inevitable problems that are going to exist, like
Right.
who's going to pay for repairs, who gets to pick the realtor when we do go to sell, when do we get to sell, what triggers when we can sell, what who's going to continue paying the mortgage, and does that person then get a larger share of the equity. Like, these are all the places where there's going to be fights and there's going to be disagreements. And that's where, the intention of, oh, we'll figure this out down the road, we get along. As soon as the fight ensues later, you're not getting along and nobody can figure out how they're going to do it. Then we have to go back to a judge, and now you're spending thousands of dollars. It may cost, a tenth of the money to get some information and some advice up front as it will take to go and actually litigate the issue later.
Yeah. Yeah. I,
So,
I see a lot of times when people say, well, we we forgot about this asset. We forgot we had that account and we didn't say anything about it. It seems like, one of the things that you guys do so well is make sure all the assets, the debts, the costs are accounted for so you can start to make the divorce work.
Yeah. Well, at least we try. Most of the time we get the full list of assets that matter. I mean, it's still possible, I guess, in an uncontested, agreed upon divorce that, parties don't tell us everything either. But for the most part, we find out and get that into the document. We also explain to them that, you don't want to deal with an asset that wasn't included, that retirement account that, we just agreed was going to be split in 10 years that doesn't hit the documents. If it's not in the document, it's not getting split in 10 years. And so these are things that we talk through just so that everybody understands, the rules of engagement and how the process really works, so that we deal with the big ticket items for the most part.
And in addition to just the stuff and the kind of the legal stuff, there's also in a divorce a lot of procedural issues and deadlines and things you have to file and things you have to do in order to get this thing done. And it seems like missing some of those is pretty easy if you don't even know what they are.
Yeah. Yeah, it happens a lot. So the way that it works is, parties are, putting together their documents, they're filling them out, they're trying to do the best they can. They're looking at the internet, they're talking to friends, they're going to even the resource center at the courts, trying to understand what they need to do. But once those documents get submitted, the court clerks are going to look at them, and there are procedural check marks that have to get dealt with in the documents themselves. If their documents are deficient and don't meet those, statutory requirements, then they're going to get kicked back. And I've seen times where people thought they were divorced, didn't realize that their documents got kicked back, and they're still married for, years down the line. And then you have, chaos ensues when they've gotten remarried, and that marriage is void by operation of law. And I've seen this happen on multiple occasions over the years. So there's real issues with just not knowing and not just managing the process. And so yes, there's definitely procedural issues with just getting the documents through the courthouse, so that you can actually get divorced the way that you want to get divorced. There's service issues. There's timing for responses or a default, or like all of these things have very mechanical timing. And the court is not forgiving if people don't do it the right way. The court's position is, well, you have to figure that out. That's on you to figure that piece out. We can't give you legal advice. And so it can cause a real problem for people who actually want to get divorced, but can't get through the process itself.
That sounds like a pretty big bad result. The whole point of filing for a divorce is to get divorced. And if you don't, I mean that's a pretty good reason for not trying to do it yourself sometimes. But there's a lot of other potentially bad results that can arise, can't they? And my first thought is just especially around dividing property.
Yeah. Yeah, especially in Oregon, what people don't necessarily realize is that in our divorces, property division is non-modifiable. So you can't go back and say, oh, I want to change what we did in this divorce judgment. Once it's agreed upon and the judge signs off on it, that's the answer. That's who's getting that piece of property. That's how much you're getting from a piece of property. And so, I hear situations and examples from people all the time when they were like, I just wanted to get out because it was I needed to move on, which is totally understandable. But you make the mistake of these are lifelong, these have lifelong impacts to, the next 10, 20 years of your life. If you could have asked for spousal support and you didn't get spousal support, or you could have gotten child support and you didn't ask for it, or, you could have gotten, half of the equity of the home and you wanted to be the nice person and you didn't get the, take the equity from the home. And there may be reasons to do all of those things, but I think not having full advice on how the stuff works, or maybe there's a way to trade things around, or still preserve some of the equity. Like, that's the part that is so important, is the understanding and the knowledge that at least if you know what you're doing and know why you're doing it, you don't have this feeling of like, oh, I gave up something that I shouldn't have. That's what we advise, during this process, is we help to give people the information and give our clients the knowledge base, so that if they want to give something up, then they at least know why they're giving it up. And maybe there's a way to trade something else, or a way to do it more creatively. They just don't know that because they handle divorces every day. So that's definitely a situation that comes up all the time.
And, a DIY divorce, to me, at least, is something that, is sort of thought about or invented for two people who are amiable, kind of together. They don't believe that they have, uh, anything different that they're thinking that the other person is thinking. Um, but a DIY can go even horribly wrong. It would seem to me, if one of these people is really a bad actor and is using a DIY divorce to hide stuff, to bully the other person. And one person is just thinking, okay, you're working in my best interest. Seems like that could happen a lot.
Yeah. And it does. I mean, we see a lot of people, unfortunately, after the fact that, the answer is, sorry, we can't do anything now, right? It's been agreed upon. It's entered with the court. There just aren't a lot of options. There are some options. And so, that's where it's worth reaching out to an attorney who does family law, because especially in the first year after a judgment is entered, there are some ways to potentially say, oh, judge, essentially, I messed up. I didn't understand what I was doing. I need to do something different. It's not modifying, it's potentially setting aside the judgment. It is not easy. It's not an easy proceeding by any means. And it's much more expensive than getting advice at the beginning to just know what you're doing. But there are some instances where it's possible to undo what was ordered. And so you always want to ask the question, outside of a year, then the bad actor part of things becomes really the only way to deal with the judgment if there was direct fraud. The inherent difficulty in a DIY situation is, how do you prove the fraud? Because it's, you're working together, and the other person can say, well, I said I had that, or I didn't have that, and they just wanted the divorce. So they're difficult issues. It'll cost somebody, again, 10 times the amount to litigate it later on, as it would be to deal with it at the beginning of the process. But those are, it's definitely important to get that information and advice.
You talked a little there about, modifying, and you can kind of help someone, even if you can't reverse the situation necessarily, by modifying some of these things if it's available and if it's appropriate?
Yeah, the main things that we can modify are parenting plans. We can modify support, both child support. Spousal support is more difficult to modify, but it can potentially be modified. The spousal support modification is a much more complex analysis, and so you definitely have to get an attorney involved for the spousal mods. But on the child support, the parenting plan, custody can also be modified. If you have joint custody, it can be modified for either party to get sole. It is very difficult in Oregon to modify sole custody from one parent to the other. So that is difficult. But those are the main things that get modified on a regular basis.
If you're going to modify and they say, okay, I want to do this, you know, are there any other requirements that you're going to that they're going to have to meet so that you can modify a decree? I mean, can you just say I was dumb? It never worked from the start, or do you have to show change of circumstances, or you know, what sort of requirements do they need to meet to even modify?
Yeah, it depends on what we're modifying. The standard for modifying like a parenting plan is just a change of circumstances and best interest of the children. It's a very low bar from a standpoint of being able to say, yeah, something's changed. I need to change. We need to do something different. It's not working for the kids, right? That's a pretty low standard. The standard for child support, is just a change of circumstances. Also, typically you're talking about a percentage change in incomes of the parties and what to support, and if childcare is dropping off, those are reasons that modifications on the child support side happen regularly. Spousal support, you have to prove an unanticipated change of economic circumstances of the parties, typically the one who is ordered to pay. So it's a much more difficult case to deal with because you have to prove that it was unanticipated and that it's substantial. And so those are the factors that a judge is looking at. And, again, the judgment is the most important thing. And the problem with DIY divorces when there is some spousal support is generally it's silent to all the other factors that we look for in a spousal support modification. And so if it causes a lot of problems and a lot of issues to try to modify spousal support if we don't have all of the facts that led to a spousal support awarded in the very beginning. So whether an award is way too high or way too low, we don't have the things that judges look for to be able to modify later. So it can really cause a lot of problems and be a situation where the answer is, sorry, we just can't, we don't have the requisite information to be able to modify.
Right.
So really, there's different standards per thing that you want to modify. Like if somebody has sole custody, trying to modify sole custody to the other parent, it's a much greater barrier because there's a legal barrier that basically says that sole legal custodian is acting in the best interest of the children. And so you have to prove first that they're essentially a bad parent before you can even get to what's best for the kids. And so it's a high bar to get over to be able to modify custody itself.
Well, let's say maybe they're not bad actors, they just did things wrong. Do you have to go to court in terms of getting a trial, or can you kind of sit down with the person, figure out what you could maybe fix, and then try to negotiate it, mediate it? I mean, are there some other options they can have rather than just having to redo the whole thing?
Oh, sure. Yeah. And we do that often when the parties can agree. And the
Yeah.
most difficult part is when the other side, who then, isn't, necessarily happy with, with what happened in the judgment, goes to the other person who they find out is happy with what happened in the judgment, it becomes,
Yeah.
There's a there's a difficulty from a from a negotiating power in that situation where the other party can just say no, and there's not a whole lot that the party who wants to change it can do. So a lot of times they do end up in front of a judge, but it is possible to negotiate certain items. They can be upon stipulation, they can be modified at times. Again, it really just depends on what's going on. And a lot of times, like I said earlier, the property division can't be modified, but the mechanics of how things get done can
Yeah.
potentially be modified. So we can't always change how much money people are getting, but we can change like how a house is going to get sold or when, or those type of things if the judgment is silent to all of that information. So it gets really excuse me, it gets really complicated. It's just a matter of really looking at what is in the document, what was anticipated at the time that it was signed by the judge, and then really analyzing what legally can be done from a modification standpoint.
We're almost out of time, but I want to ask one more thing. If someone, or have you ever had a time where, someone in a DIY divorce had come to you before the final dissolution judgment and said, here's what we've decided on. Can you take a look at it? Does that kind of stuff happen? And should it happen?
Yeah, we do that all the time. That's a service that we offer to people all the time. They can pay for a limited amount of time and advice to review documents before they get submitted to the court. It's more rather than the specific language. It's more about the overall division of things,
Right.
to be able to talk through. Okay, what are you trying to do? It's not, we're not writing it. I mean, we can get hired to write it for them, but it's more of a situation where we're talking through like, okay, if you want to do this, how are you going to do this, and how do you want to handle this particular aspect of it? The other thing we didn't really talk about is, in a DIY divorce, people are trying to put together parenting plans for kids who, that they don't do this all the time. And so a lot of times don't know to think about like, okay, how do we deal with summers? Especially with young kids who aren't in school yet. How are we going to deal with the school calendar? How are we going to deal with holidays, spring break? What happens if one parent, wants to go on vacation? How do we deal with that? So that's another big part of putting together judgments for people that we work really hard on to try to get a parenting plan to last as long as possible. And we know where all of the pitfalls are, and so we try to help parties plan for that in advance so that they have the answer ahead of time, and so that people aren't having to then fight over it and having to file a modification that's going to cost money, take 6 to 8 months, 10 months to get in front of a judge to even change it as it is. And it just creates even more chaos than trying to think through some of the normal things that come up.
Well, so even if they are going to do a DIY, coming to you before they sign it's a pretty good idea.
I would highly recommend it. That's where the little bit up front, and yes, I get it costs money, but the little bit up front saves thousands later.
Yeah.
I've seen it so many times over the years. We can really, in a short amount of time, help somebody understand the pros and cons. Is there a better way, before signing off on something that's just going to cause a bunch of time and money later to fix?
Yeah. Wow. Well, Louis, thank you again for sitting down to join us and talk about, what you can do if your DIY divorce went wrong.
Yeah, you're welcome.
Again, thanks. It's just a great, great topic. And everyone else, thank you for joining us. Anyone further questions, feel free to contact our firm. We can get you connected with an attorney who can help you.